In continuation of Nnamdi Kanu'S proceeding in the UK Court Appeal Court, of course, I held the female lawyer that was defending Nnamdi Kanu. He's such an intelligent and passionate lawyer for indigenous people of Biafra. I know what we should be doing now is prayers. And I'll have to leave it so that you will hear what happened today in court. Today is 22nd. I announced it beforehand that 22nd, according to what we have, is the day they will do the hearing. Of course, that should be the final. Let's go there.
The respondent was looking for evidence to substantiate the allegations before considering imposing or before deciding to impose sanctions, not when the case meets the evidential thresholds. So that's sanctions. Diplomatic protection is another option that is available. And that's described in the prisoner policy guidance at page 104 of the bundle.
I don't know much about this, Ms. Kilroy, but can you do that where the individual is a dual citizen?
It is, yes, you can. There may be a dispute with the member state, the other state as to whether they will accept that dual protection is being exercised, but it is possible on the respondent's approach with them. And that was done, in fact, in relation to Nazanin Zahawi-Ratcliffe, who is a dual national. And you can see, so diplomatic protection is dealt with in the prisoner policy guidance at page 104. And you'll see at 105. At 104, you'll see that diplomatic protection at the bottom of that page. Diplomatic protection is the process under international law by which one state pursues a claim against another state on the basis that it has committed an internationally wrongful act against its nationals. So the commission of an internationally wrongful act is the necessary prerequisite for considering whether to impose it. And then you'll see again at 105, it's extremely rare. This is just under the heading diplomatic protection, a right of the state, third paragraph. In practice, diplomatic protection is very rare and considered on a case-by-case basis, exercised at the discretion of the Foreign Secretary. This means there's no duty to exercise it, even if the conditions to exercise it are present. The conditions that must be present to consider diplomatic protection include the commission of an internationally wrongful act, the exhaustion of local remedies and proof of nationality. And then there is guidance on diplomatic protection. You can see there they may take up a claim for a dual national in a third country. HMG will not normally take up the claim of a dual national in their country of other nationality. However, exceptionally, HMG may take up the claim of a dual national against their country or other nationality where it has treated them as British nationals in the circumstances that gave rise to the injury. So,
is that this case?
Well, my lords, I can see that is something that would have to be considered as to whether he had been treated as a British national in this particular case. But the point as far as this submission is concerned is that these are all criteria that need to be considered, and one of the criteria is whether there's been an internationally wrongful act against a British national.
Yeah.
And you can see that, again, in that submission, in the ministerial submission of September 2021 at 139, that diplomatic protection was one of the options considered. We could consider extending diplomatic protection to Kanu, although it is unlikely that he would meet the criteria for consideration as domestic avenues have not yet been exhausted. So that's the reason that's given. It's not the reason that he's not being treated as a British citizen in the Act. I should say, I said at the start that Mr. Kanu was travelling on a British passport when he was transferred and rendered. So diplomatic protection is one of the options. And
but anywhere local remedies
yes,
have not been exhausted.
Well, that's right, but that also means when it looks as if those remedies are not effective, and it's part and parcel of the assessment that has to be made whether there's been an internationally wrongful act, except there are other criteria. But diplomatic protection is one of the options available. It's simple. I absolutely accept that it is the last option in a series of options, but it is an option, and it is a further reason when someone has been detained in solitary confinement for 2 years to reach a conclusion on whether they were the victim of extraordinary rendition or not. So, my Lord, calling for release, making a statement about whether someone has been the victim of an internationally wrongful a breach of international law, in this case extraordinary rendition, sanctions, and finally diplomatic protection are all options that are available as escalation when the expressions of concern, the note verbal, the lobbying has not worked. And in my respectful submission, reaching a concluded view, or clear and concluded view, as opposed to a non-provisional view, is a critical component of properly considering those options and could make a difference. So can I turn now to the grounds of appeal? And the first ground...
Ms. Kilroy, just before you do, can I just ask you this, just talking around this question of the concluded view, taking it in stages, I assume you accept that initially at least the Secretary of State was entitled to form a provisional view.
Yes.
So when was it, you say, that he was obliged to come to a concluded view?
When the evidence warrants it, my Lord.
No, when on your case,
oh, I see.
Was he obliged to come to a conclusion? And then obviously the follow-up question is why? Because this is actually all temporal. So I just want to try and understand what the case is as to when and why the position would have shifted.
Well, I mean, the first and most obvious answer to that question is there's not a precise date. I, of course, accept on the appellant's behalf that in the initial days when an individual has been detained, a process of investigation has to be undertaken to establish the circumstances in which they've been detained and the lawfulness of their treatment. And I also accept, indeed, I assert that in that period of investigation, the respondent is quite right not to simply take no action, but to express concerns based on preliminary views that he is able to reach on the treatment of that individual. But as the evidential picture develops, then the Secretary of State is, in my respectful submission, obliged to, as soon as it is possible to do so, reach a clearer, non-provisional view. And in this case, what happened was that the Secretary of State was, for many months, requesting explanations by way of note verbal. You can see that from Ms. Broughton's statement as to what had happened to Mr. Kanu, the circumstances of his arrest and transfer. Those requests started going out as early as the end of December 2021. and was getting no response.
How do we know that there was no response? The interactions were mainly, as I understand it, face to face. And then fairly recently, a note verbal from Nigeria to UK. We're not told either what the response was in the note verbal, nor what various representatives of Nigeria said.
Well,
Meetings, are we?
Well, my lord, we are told that there wasn't a response to the questions or allegations that were made about the transfer, and I'll have to track down the paragraphs of Ms. Broughton's statement, but there is no dispute, as I understand it, between the parties that that there has never been, and it's not clear to me whether this most recent note verbal is a satisfactory answer to the questions that have been raised, but at least until that point, there has never been a satisfactory answer from the respondent, from the Nigerian government, from either the Kenyan government or from either the Nigerian or the Kenyan government to the respondent's questions in relation to the circumstances of the transfer. And I will make sure you have the paragraph numbers in Ms. Broughton's statement to that effect, or in the evidence. But that is our understanding. There has not been an answer. There's not been an explanation given. And one of the important things about the evidence that was below, and I haven't taken you through it, but it's recorded in the judgment, is that the Nigerian government, we do have an affidavit that was submitted by the Nigerian government in the Nigerian proceedings, which effectively admits the unlawful transfer, because it positively asserts that there was no extradition. There was no need to comply with any extradition treaty, according to the Nigerian government, because Mr. Kanu was said to have jumped bail. And it was the Nigerian government's position in that affidavit that they were therefore entitled to go onto Kenyan soil and apprehend him and bring him back. Obviously, that is not a position that is consistent with any law. And the Kenyan government had also put in their evidence, and again I can give you these references, the Kenyan government had also put in their evidence to proceedings in Kenya that Mr. Kanu had entered the country and was recorded as having entered the country through immigration, but there was no record of him having left. And there was no extradition. They were not party to any extradition. That's their case, that's their defence.
And what is the appeal to the Supreme Court about?
Well, my lord, perhaps it's not very long. The appeal to the Supreme Court is at 168 to 192. And it is focused on the jurisdiction issue. I've given you the wrong page number. That's the start of Mr. Ejimako's statement. It's page 185 of the bundle. And it ends at 191. And what you'll see is that what is said, just to give an example, you see particulars of error on page 186. The court below relied heavily on the alleged mode of entry, brackets, abduction and extraordinary rendition, only brackets, of the respondent from Kenya to Nigeria as a basis to hold that the trial court had lost its jurisdiction to entertain the charge before it, even when it is not in contest, and there is sufficient evidence and the proof of evidence contained in the records of appeal before the court to show that the respondent was standing trial and flouted the orders of the trial court and jumped bail. And then at 3, Roman 3, the court below erred when it held that the executive arm of the government must not be allowed to benefit from his wrong, brackets, abduction and extraordinary rendition of the respondent, end brackets, when in fact and by its judgment, the respondent was allowed, that's Mr. Kanu, to benefit from the illegality of his disobeying the orders of the court when he jumped bail. And I should pause there to say that that's why I pointed out the judgment of the Nigerian court in January 2022. He left the country, he was on bail when the Nigerian military raided his home and attempted to kill him, according to the Nigerian court. So that's why he fled. Disobeying the orders of the court when he jumped bail and was rewarded with a discharge from the charges pending against him at the trial court, thereby occasioning a miscarriage of justice against the state and the victims of the crimes. And the same point is made in a number of different ways. And you can see a similar point made at ground 3.
I appreciate your cases. All this is nonsense, but at the moment I'm looking at what the grounds of appeal are.
Yes.
It doesn't seem to me, looking at these grounds, that they involve an admission of illegal behaviour on the part of the government.
Well, my lord, they don't challenge the conclusion of the Court of Appeal that transferring the Mr. Kanu from Kenya to Nigeria in the absence of an extradition, an order for extradition, was amounted to an extraordinary rendition. And the Court of Appeal in its judgment went through both domestic law, in a local human rights law that was Africa-wide, and international law. It looked at Bentley, for example, looking at the House of Lords decision in that case.
No, I understand that, but
so these are not challenged.
Ground 3 at the bottom
Yes.
of page 187 says the court below occasioned a miscarriage of justice when it held that the rendition of the respondent is unlawful.
Yes. Well, my lord, that case is about a domestic principle. Patrick Jovins and others is about a domestic transfer across states in Nigeria, as I understand it. So it's the international law finding. These are all domestic law arguments about the consequences for criminal charges of this international law wrong. That's what this appeal is about. And so that is why, and what's more, if your lordships look at the judgment of the Nigerian Court of Appeal, and it may be worth having a brief peruse of some of its key conclusions. The point is that in those proceedings, there was no evidence, proper evidence, dealing with the extradition in those particular proceedings. The affidavit I've referred to is in another proceedings. And so what the court found is that there was no proper denial of the allegation of extraordinary rendition. Now, this is going on appeal to the Supreme Court. There isn't going to be any further evidence in the Supreme Court in relation to the extraordinary rendition. So, my lords, the basic point is that the evidential picture is not going to change. The Nigerian courts of various hues, as recorded in the judgment below, have all found that this amounts to an extraordinary rendition. There is, I accept, that's why the appeal, there has been a stay on the appeal. There is, I accept, a possibility that the Nigerian court may find, notwithstanding the Supreme Court may find, notwithstanding this serious breach of international law, that Mr. Kanu can go on to be tried for charges that carry the death penalty, which is what he's facing. But that would not be a reason for the Secretary of State not to reach a concluded view on whether there's been an extraordinary rendition. Indeed, that would be a reason for reaching such a view, because if from an international law perspective, as the Nigerian court itself found, an extraordinary rendition invalidates such actions and would render any implementation, even if the respondent accepted it more widely, of the death penalty particularly egregiously unlawful. So, my lords, we still come back in my respectful submission to the same point, which is that the evidential picture now, 2 years after Mr. Kanu was detained, first detained, after multiple requests for further information from the Nigerian government, after the United Nations Working Group on Arbitrary Detention has itself expressed a view, that's recorded in the judgment as well, has itself expressed a view that Mr. Kanu has been the victim of extraordinary rendition. And that's in the supplementary bundle at pages 507 to 523. That's the UN Working Group on Arbitrary Detention. And when the Nigerian courts have reached that view on the evidence before them, and there is no further possibility of any further material emerging on that question of whether he's been extraordinarily rendered, because the position is so clear, there is no reason for the respondent's view to remain provisional. I mean, in short, in colloquial language, what is the respondent waiting for? What does the respondent expect to emerge as a result of future proceedings, which is going to change the position? And indeed, that's one of the questions that is raised by ground 3. There is no proper explanation of what it is that the respondent is waiting for. There isn't going to be an evolution of any evidence on the critical whether there was an extraordinary rendition.
Have you seen it? That Nnamdi Kanu has no case to answer. They're just doing all these things just to buy time, just to see if he will die, because they know they are supposed to release him. UK knows, Nigerian government knows, Kenya knows. All the saboteurs, they know he has done nothing. So God will help Nnamdi Kanu. God will help these lawyers to win this case. That's my prayer, and I know it's your prayer too. Thank you very much again and again on this channel. God bless you.